Welcome back to Carolina Journal Radio. I'm Donna Martinez. We have promising news to share with you in the effort to advance freedom in the healthcare arena. A Wake County Superior Court judge issued a ruling in the case filed against the state of North Carolina by a Forsyth County surgeon. Dr. Jitendra Singh is seeking to offer MRIs to his patients. He says he can do it at a lower price than they're currently being charged elsewhere. But Dr. Singh is being prevented from doing that by an archaic state law, and that's what makes this ruling so important. Jon Guze is Director of Legal Studies for the Locke Foundation. He is following the case closely and joins us now with an update. Jon, welcome back to the show.
Thanks, Donna.
Tell us what the judge ruled and why it's significant.
Well, the ruling came in response to a motion by the state of North Carolina to dismiss Dr. Singh's case. The state said that the case should be dismissed for two reasons. One is that he lacks standing because he had failed to exhaust all his administrative remedies, and also said that he'd failed to state a claim for which relief could be granted.
What does that mean for those of us who aren't attorneys? What's the upshot of the ruling?
Well, the upshot of the ruling is that the case can go forward, and it was really the right call in this case, because to suggest that Dr. Singh lacks standing for failure to exhaust his remedies would have, just to put this in perspective, at the time Dr. Singh filed this complaint, there were no certificates of need available. That means there was no possible way he could have bought and started operating an MRI machine in Forsyth County. If his patients needed that services, he had to send them to one of the big hospitals that were providing that service at a high cost. It simply wasn't an option. Now, after he filed the complaint, the board that administers these matters decided that they would make one more certificate of need available in Forsyth County, and they said, like anybody else, he could apply for it. He estimated that it would have cost about $500,000, $500,000 just to go through the application process because of all the legal fees.
That is stunning. How could a doctor possibly incur that kind of cost?
Well, a small operator like Dr. Singh couldn't possibly do it, and the thing that makes it so grossly unfair is that he could actually have purchased the machine for $750,000. So to suggest that he ought to spend $500,000 simply trying to compete for the privilege of buying a $750,000 piece of equipment is just absurd. That in and of itself shows that this law is unfair.
Okay, so the state essentially wanted the judge to say, nope, this case can't go forward, it's dismissed. But the judge said, no, it will go forward.
It will go forward, and that's great news for Dr. Singh, and it's great news for the rest of us because it means that this case can proceed to be heard on its merits. I'm sure it's going to work its way through the courts, but ultimately we're hoping that it'll make healthcare much more affordable and accessible in North Carolina.
Dr. Singh's contention is that a state law, it's actually called Certificate of Need, you referenced it, is what is preventing him from offering this, and it involves this complicated process that you've described here. Give us a little bit more information about this Certificate of Need. Essentially, you have to have a government permission slip to do something?
You do. North Carolina's original Certificate of Need law went into effect in the early 1980s, and the objective then, as now, was to limit the number of providers. The thought was that somehow by limiting the number of providers, you could reduce costs. That law was struck down as unconstitutional almost immediately, but the state legislature did it again, and the new law has so far survived challenge, but it's never been to the state Supreme Court yet. So we're hoping this case will eventually reach the Supreme Court, and the court will say that this law, like the previous law, is unconstitutional.
Jon, it seems to turn economics on its head because there's actually a state agency or division, a group, that determines whether or not there is a, quote, need for a particular medical device or a service. How can state government possibly know that?
Well, they can't know that, but it's even worse than that, frankly, because many of the people on the board that makes these decisions are members of the work in the existing healthcare system, and they are on the side of the big hospitals and other big providers that have the current con laws, that have the current certificates of need, so they have an effective monopoly on the service. So they're not dispassionate in their decisions about these things. They've got an incentive to reduce the number of providers.
Jon, there is a debate over whether or not this relaxing of certificate of need or complete repeal of that and allowing a competition to go forward, whether or not that would lead to lower costs and more opportunities and more access for consumers of health care. When you wrote a piece about this, available at jonlocke.org, called "A Victory for Healthcare Freedom," about this court ruling to send this case forward, you make a note that there's a lot of research on this.
There is. In our brief that we filed in this case, we cited dozens of reports, all the research that's been done since the last time the Court of Appeals heard a challenge to this law, and all of it, overwhelming evidence that shows that when you have con laws, healthcare is less accessible and more expensive than when you don't. This appears over and over again, and of course it's just what common sense and economic theory would lead you to expect.
So, John, do you predict that this case, the Dr. Singh, will prevail in this?
It's hard to say, Donna, because there's a long history in this country of courts deferring to legislators on this kind of matter. When it comes to economic regulations, economic rights are really second-class rights in this country, and so courts are tempted to say, well, if the legislature thinks this is a legitimate use of government power, then we're going to defer to them. And in this case, that's still a possibility, because when the legislature passed the second con law, they added a series of legislative findings that simply stated in a conclusory sort of way that reducing the availability of certain medical services will reduce the cost. Now, that's why we provided all that evidence, because the evidence doesn't support those findings, but it's going to be up to the Supreme Court in the end, I suspect.
Let me see if I understand this. The case is going forward. If he prevails, the court would rule that it is unconstitutional, preventing him from doing this, from offering this equipment, this service to his patients. If that occurred, John, then certificate of need law would be struck down.
Well, I'm sure that if that happened at the at the Superior Court level, it'll go up to the Court of Appeals and ultimately to the Supreme Court. But if the Supreme Court agreed and the law was struck down, then it would be there'd be all kinds of new opportunities for medical entrepreneurs to provide new goods and services.
Let's say that the case does not go Dr. Singh's way. It sounds like the legislature could, on its own, decide to repeal this law or make exceptions.
They certainly could, and they should, and we've been urging them to do that for years. One of the reasons I'm so excited about this case is because we've seen this happen in the past when there's litigation that starts to expose the problems with the law and make the law seem untenable, then it gets the legislature's attention. They're more likely to do something to reform it. So we're hopeful that we might win a victory that way, if not in the courts.
It's a fascinating ruling, a very significant ruling in this case that could lead to more healthcare access and healthcare freedom. The case is Singh v. DHHS. That actually stands for Department of Health and Human Services, a state agency. We've been talking with Jon Guze. He has been writing about this. You can find all of his analysis of this case and this issue at jonlocke.org. John is Director of Legal Studies for the Jon Locke Foundation. Thank you, John. Good to talk with you.
Thank you, Donna. It's a pleasure.